Hello, everyone, and welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. Welcome. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. We are the employment lawyers and disability insurance lawyers in Canada, coming at you today for another, hopefully, interactive Q&A. So if you're just tuning in, and you're wondering what this live session is all about, this is your chance to speak with an employment lawyer, to speak with a disability insurance lawyer as well, and get your questions answered. Again, this is a Q&A. We're here to field all sorts of questions when it comes to your employment, any difficulties you're having with your employer, any termination or severance pay entitlements that you have if you've been let go from your employer. And guess what? Your severance entitlements are significant. They're not just a couple of weeks per year of service, as well as any issues related to medical leaves of absence at work. So if you're dealing with a medical leave, if you're dealing with an insurance company and disability insurance when it comes to your medical issues, please go ahead and post any questions you have on whatever platform you're viewing this on. Go ahead and ask your question. You don't have to include any confidential information. Ask a general question, and I promise I will get to that question and I will help you on your way to resolving whatever employment or disability insurance issue you are having. So again, this is a live Q&A with an employment lawyer and disability insurance lawyer. Go ahead and post your questions right now. Let's get the ball rolling on those questions. Before we get there, I do want to take a couple of minutes to do a couple of things, actually. Number one, wanted to provide our contact information. So if you're looking to reach out to us and perhaps have a conversation off air, maybe you're a little shy, a little bashful, you'd rather have a call or a meeting confidentially, that's absolutely fine. The first place you should visit is our website, employmentlawyer.ca. You can see it on your screen right now. Go ahead and visit our website. Of course, we've got all of our contact information there. So if you want to give us a call, if you want to reach out to us by leaving your information or sending us an email, we've got all of that information there. We've also got a ton of resources. We've got a ton of articles, video clips, blogs, setting out employees' basic rights when it comes to things like severance, when it comes to things like changes to the terms of your employment, really anything under the sun when it comes to employment law. We've got a ton of resources there. If you want to email us, and I would encourage you to do so if you're dealing with an employment issue, our email address is on the screen right now. It's very simply help@employmentlawyer.ca, HELP@employmentlawyer.ca. Go ahead and send us an email. There's absolutely no cost in doing so. There's no commitment in doing so. Give us a brief description of the situation you're dealing with. Give us the basics. Don't give us a 10-page summary of your entire career. Give us the basics. Ask your question or raise your concern. And I promise someone for our team, from our intake team, who's standing by, will contact you back and get you moving in the right direction. So again, that's help@employmentlawyer.ca. For those of you just tuning in after a couple of minutes, as a reminder, this is an employment law Q&A. My name is Alex Lucifero. I'm an employment lawyer, partner with Samfiru Tumarkin, LLP. We are the employment lawyers. We operate in British Columbia, Alberta, and Ontario. If you're in any one of those provinces, go ahead and field your question. More than happy to advise you on any employment issues that come up, or if, again, you want to give us a call at the office, do not hesitate to do so. You can search us up and get a hold of us. However, whether that's by telephone, email, leaving your contact information on our website, etc. Okay, so that's the administrative stuff out of the way, guys. Again, don't be shy to reach out to us off air. Wanted to talk about I actually wanted to talk about a couple of matters today, but I see some questions coming in, so I'm actually gonna keep this short. We obviously have radio programs, the Employment Law Show, and TV programs of the same name that we do on a weekly basis. And as part of those shows, we always want to talk about a matter that came across our desk during the week or that day. It's a segment we call The Week That Was. And so I actually wanted to talk about a matter, a gentleman I just spoke with this morning, actually. So this is hot off the press, as they say. And it's to deal with severance. And the reason why I wanted to talk about a severance issue today is because, unfortunately, and we're coming at you here in July of 2023. Unfortunately, over this year, we've seen a pretty sharp increase in terminations. I think it's a sign of the economy, and I think there's a fear, of course, recession moving forward. I think lots of employers are tightening their belts and battening down the hatches, and unfortunately making difficult decisions as far as laying off staff. We've seen tons of layoffs across the tech sector, of course, but we're seeing it across lots of different industries as well. And so it's important to remember when it comes to severance, almost always, if not always, an employer will lowball an initial severance offer to an employee. It's not done in a kind of crass or done in a vindictive way. This is a business interaction. The employer is looking for a good deal here, for a good exchange in letting an employee go. And you, as the employee, or potentially the employee in those circumstances, needs to also be looking out for your best interests as well. And you should be treating it as a financial transaction and situation as well. And so, in those situations, before you accept any kind of severance offer, please, it's extremely important that you receive advice from an employment lawyer. Do not blindly sign off on any kind of severance offer that you receive, even if you think it's generous, even if you think it's reasonable. It's always crucial to get employment law advice first. If you sign off and accept that severance offer and then have second thoughts after the fact, it's a done deal. There's nothing that you can do to undo acceptance of a severance offer, even if ultimately you felt pressured into signing it. Unfortunately, there's no way around having accepted a severance offer. So before you accept it, make sure you get legal advice. Make sure you speak with an employment lawyer and get proper advice from a professional as to whether that offer is reasonable or not. If the offer is fair and reasonable, we will tell you, and we will give you our blessing to go ahead and accept it and sign off. Unfortunately, what we see is that the vast majority, again, if not all severance packages that we see are deficient in one way or another. A lot of times they're deficient in the actual amount of severance being offered. The severance they are offering in terms of number of weeks or number of months is going to be deficient in and of itself. It's not enough for an employee of a certain age, position, and years of service. The other way in which we'll see deficiencies in severance offers is that they don't include all components of an employee's compensation package. It's important to remember, if you're let go from your job, your severance should be based on your total compensation. It should include things like commissions or overtime pay or bonus, benefits coverage, pension contributions. All of those items need to be factored into the equation. It's not a base salary only calculation. And so again, whether we're dealing with the actual amount being offered or the various components of your compensation that may or may not being offered, it's important to remember that both of those issues need to be addressed. Case in point, spoke to a gentleman this morning, 26 years of service with the same employer, very long service employee in his early 50s in a management level position. So this is not, a general laborer working for a construction company that can move on to new employment very quickly. And by the way, those construction employees are owed severance as well. It might be a little bit less than a management level employee would be owed. It's important to remember age, position, and years of service are the factors that are taken into consideration when assessing severance. This gentleman was only offered about 8 months as a severance package, having been with the company for 26 years. On the face of it, one might think, okay, well, 8 months, is not a small amount of money. This gentleman was making good money, so that's a significant amount. On the face of it, you might think, oh, maybe that's a reasonable number. It's not. It's actually less than half of what this employee is going to be owed. This gentleman is looking at a severance package of 18 months and over. He might be owed as much as 24 months, actually, of severance. That's months, not weeks, right? He was offered 34 weeks, which again is about 8 months. You might be looking at 2 years or 24 months of severance. Clearly, there is a difference there that needs to be addressed. These are the kinds of differences that we see in what employees are offered upon termination of severance and what they're actually owed. We're actually now going to be working with this gentleman to get him his proper severance entitlements. The good news, if we can call it that, is that this situation is actually relatively straightforward. The law is not complicated on an issue of severance. It should be resolved relatively easily with some communications and some discussions. Things don't have to get heated. Litigation is not necessarily required to resolve these kinds of matters. A lot of them are resolved with a conversation or two with a few back and forth discussions and some negotiation. So that's my week of the day, guys, or case of the day, as we call it. It's an opportunity again to just provide some guidance there and some wisdom based on the conversations that we have every single day with the people that we speak with. If you find yourself in this situation where you or a family member or a friend have lost their jobs, the key point to remember here is do not sign on the spot. Do not accept a severance offer without speaking to an employment lawyer first. Odds are you're going to be owed more severance than what the employer has actually offered. That shouldn't be shocking or surprising to individuals in those circumstances. All right, thank you for that. Hopefully that provides some degree of advice for individuals out there who are in the process of being let go from their jobs. Not an easy situation, certainly. Let's get to the questions, guys. And again, for those of you just tuning in, this is a live Q&A. And welcome. You're just in time. We've now reached the portion of the segment where I'll be answering your questions. This is live, completely unscripted. I have a good number of questions here lined up. So again, if you're just tuning in, go ahead and post your question. I don't need your name. I don't need your personal information. Just go ahead and post a general question. It could be about severance. It could be about anything related to your employment. Maybe you're dealing with a boss that's not treating you properly. Maybe your employer is asking you to change your employment somehow. Maybe it's a change in position. Maybe it's a change in pay or compensation structure. Really, whatever the question is, go ahead and post it right now. I promise I'll get to it before the end of the segment. We've got about 19 minutes left here. And also, if you're dealing with any kind of medical issues at work, if you're having to take a medical leave of absence, if you're dealing with the insurance company in that respect, if your insurance company has denied disability benefits to you, again, go ahead and post a question if that's relevant to your situation, and I will get to it. Same thing with medical accommodations in the workplace. It's actually an issue that is often forgot about by employees. Keep in mind that your doctor, if you're dealing with a situation at work, your doctor can be a support person there. Your doctor can provide you with a doctor's note that provides for some degree of accommodations when it comes to your work. Maybe you're dealing with a physical issue and you need to take more frequent breaks. Your doctor can provide a note to that effect, and your employer has to respect that note. Maybe you're dealing with some mental health issues and you need to be working from home, for example, as a way of minimizing those issues. Your doctor can write a note and your employer has to play ball. These kinds of accommodations happen all the time. They're extremely important. They are your right as an employee. Don't be shy to use them. All right, guys, that's enough preaching and the end of the monologue, as they call it. Let's get to the questions here. Kalista is first in line on YouTube. Thanks so much for asking your question, Kalista. She asks, I'm almost 70, and recently my job was outsourced to a third party. Instead of terminating me, they're offering me a new job that's completely different to my old position. Do I have to accept this? What an excellent question, Kalista. And it's exactly the kind of situation where an individual needs advice from an employment lawyer. So this is what we call a change to an employee's terms of employment. It can also potentially be called what's a constructive dismissal. A constructive dismissal is effectively, or potentially at least, a breach of contract situation where your employer has made such drastic changes to the terms of your employment. They've just changed the game so significantly that you'd be allowed to actually claim that they've breached your contract. Even if you don't even have a written contract, this could be an implied or verbal contract. And that's the situation that I believe Kalista is dealing with. Kalista, if they have changed your position in an extremely significant way, and you said it yourself, it's completely different to the old position that you have. And if you have some concerns about that change, so of course, if you welcome the change and you think it might be positive, listen, have at it, right? Enjoy it. It's obviously something positive. But if you're concerned about the change, if it's an area of work that you have absolutely no expertise in, or that is something that you're worried might have a detrimental effect on your health or a detrimental effect on the future of your employment with the company, you would have the right, Kalista, to reject that kind of change. You can go back to your employer and say, sorry, guys, but I don't agree with this change to my position. I'd like my old position back. And your employer will have to do one of two things. They'll either have to propose something to you that's acceptable to you, right? So they'll try and remedy the situation somehow. Maybe there's another position that's available that you'd rather or that you prefer, right? Or alternatively, Kalista, the employer would have to let you go and pay you severance. As a 70-year employee, if you've been with the company for a period of time, your severance entitlements are going to be significant at that age. Again, keep in mind, age, position with the company, years of service with the company are all relevant factors, really the factors that need to be considered when assessing an employee's severance entitlements. Kalista, if you want to follow up and give me your years of service, I'd be happy to give you a better sense of what your severance entitlements are. But the main point is here, no, you don't have to accept a significant change to your position. You can treat a significant change like that as a constructive dismissal, as a breach of contract situation. And either the situation could be resolved internally by the company making you happy and offering you something that you can live with or that you're happy with, or alternatively, you would be owed severance. Now, I do want to be clear, Kalista, before you go back to the company and says, no, Alex says I'm owed severance, so I want a severance package, I'm not accepting a change in position, let's have a conversation off air. Before you say yay or nay to the change in position, let's get into the details. I want to know exactly what this new position is. I want to know if there are any changes being made to your compensation package, are changes being made to your schedule, any other changes happening. I might want to have a look at any kind of employment contract that you might have signed with the company. We need to get into a little bit more detail before we really firm up a strategy and approach towards the company, because we do have to respond back somehow, some way. The good news is, to answer your question, no, you don't just have to accept any change that an employer asks you to make. The employer needs the employee's consent. You have the option of either accepting or declining a significant change to the terms of your employment. And you don't have to accept, you don't have to go along with whatever your employer is instructing you to do. Kalista, you know where to find us. help@employmentlawyer.ca is the email address. employmentlawyer.ca is the website. Contact us there, send us an email, give us a call, however you want to get a hold of us. Let's have a conversation off air. I'd be more than happy to do so myself. Let's get into the details and figure out what the best approach is moving forward. The good news is you have options. Great question. Great question to start off the session today. All right, next up in line. Hi, just wondering, where is the line of employer knowing what one does on disability? This is from Ocarnario of Time 98. Forgive me if I'm not pronouncing that correctly. Interesting question. Where's the line? To what extent does an employer need to know or have the right to know what one is up to when they're on disability leave? The answer is this, Time 98. Very little, in fact. An employer doesn't really have any right to know what an employee is up to on a day-to-day basis if they're on a medical leave of absence. They don't even have a right to know necessarily what the diagnosis is. They don't need to necessarily know what condition the employee is dealing with, whether that's a physical condition or a mental health condition. An employer needs to know what the prognosis is when it comes to a medical leave of absence. They have to have some sort of information from a medical professional as to confirming actually that the employee is medically unable to work. So any kind of doctor's note or letter from a doctor needs to confirm in fact that yes, this employee is medically unable to work. And the doctor may want to give a sense of what the timeline might be. So maybe it's, off for a medical leave of absence for the next 3 months, or off until, he can be examined again, or she could be examined again. There has to be ideally some degree of timeline there. Now, listen, if the timeline is indefinite, right, then the doctor is going to say that it's indefinite, right? And the doctor will provide an update when there is one to provide. But ideally, you do want to keep an employer posted. You want to keep them aware, right? And keep that line of communication going when you're on a medical leave of absence. Every time you meet with your doctor, you might want to provide an updated note to your employer. But do they get to know, Time 98, to what extent you're active during the day, or to what you can and can't do necessarily? No, an employer doesn't necessarily need to know I would say with one exception here, Time 98, if we're talking about an accommodation issue while you're actually working. So again, the context of the explanation I just provided is when you're on a medical leave of absence. When you're on a medical leave of absence, all you need to provide to your employer is a doctor's note confirming that you're on a medical leave of absence. If you do that, they can't say boo, right? They've got to let you take your leave, right, and not bothering you during it. If, however, this is an accommodation situation, right, and you're able to work, but there are some limitations as to what you can and can't do, and your employer's provided a doctor's note, right, to that extent, well, then there, of course, your employer can start asking questions. So let's say we're talking about a job requiring some degree of physical labor, right? Your employer would have the right to know, right, how much could you lift? How many pounds can you lift? What kind of physical exertion can you sustain or not? How many breaks do you need during your work shift or not? That kind of information becomes relevant in an accommodation situation. But what you're doing at home in your private life when it comes to the medical issues you're having is really none of the employer's business. Hopefully that helps answer your question, Time 98. And again, like Callista, if your employer is giving you a hard time, and I hate to say it, folks, but, and I just spoke to someone today actually in this kind of situation, unfortunately, it's the case that employers will give employees a hard time when they're dealing with accommodation requests, when they're dealing with medical leaves of absence. It's unfortunately the case that lots of employers will ask questions where it's inappropriate to ask questions, and they will poke and prod where it's inappropriate for an employer to be doing so. And a lot of times they will even refuse accommodations to employees and say, no, I'm sorry, we can't do that. We can't accommodate those medical restrictions. That is potentially discrimination under the Human Rights Code in Ontario. An employer needs to accommodate an employee. They have to play ball when it comes to accommodations, to the point of what we call undue hardship. What undue hardship means is actually it's expected that it's going to be difficult for an employer to accommodate an employee. That kind of difficulty is kind of fair game. It's not going to be easy for an employer. It's only when the hardship is effectively almost impossible to accommodate that an employer gets to say no. Those situations are very, very rare. All right, we've got about 8 minutes left, folks, and there's a couple of questions, a couple of follow-ups here that I'll get to before we start wrapping up. Next in line is Kelly on YouTube. Kelly, thank you so much for your question. Kelly asks, I was put on a temporary layoff in May. Yesterday, they posted a job in my department, called it something different, but the job description is exactly what I applied for a year ago when I got the job. Can I do anything? Kelly, very interesting situation. The first point I'll make is a temporary layoff isn't necessarily legal or allowed. It's similar to the constructive dismissal situation we were talking about earlier in the live stream. A temporary layoff is a major change to the terms of your employment. Your employer is basically sending you home, right, without pay, when the status quo is, of course, employment, right, work. You're working for the company in exchange for remuneration, in exchange for a salary and pay, right? If that situation changes significantly by them sending you home, that could very well be a constructive dismissal. It could be a breach of contract from your point of view. So the first point I'll make, Kelly, is don't just assume that your employer can put you on a temporary layoff. In most cases, a temporary layoff is a constructive dismissal. It's a termination, right? In which case, the better option by far is to just get your severance, get your proper severance entitlements, and move on to new employment. You don't want to just be sitting on the bench waiting to be called back for work, because something like this can happen. You can see a job posting for exactly your position, right? And that's not a situation you want to be in, of course. Now, the other side of this coin, Kelly, and I would encourage you to reach out to us and let's have a chat off air and let's review, Kelly, any contracts that you might have signed with the company. So if you started with the company a year ago, it's possible that you signed an employment contract that's 2, 3, or 4 pages long. Maybe it's 8 pages long, right? In that employment contract, Kelly, there might be a term there that allows the employer to temporarily lay you off. So there might be a provision or a paragraph in your contract that says, we, the employer, have the right to put you on a temporary layoff. If that's the case, Kelly, then unfortunately, whether you knew it or not at the time you signed that contract, at the time that you accepted that job offer, you've allowed the company, you consented to the company being able to temporarily lay you off. And despite the fact that they've posted the position under a different name, they're still legally allowed to put you on a layoff. Now, again, I want to be clear, that would only be the case if an employee has an enforceable employment contract that actually allows the employer to temporarily lay off the employee. If, Kelly, you have a contract, but it doesn't say anything about temporary layoff, or if potentially you have no contract at all, maybe it's a very brief offer letter, right, that states your position, pay, vacation, benefits, and that's it, right? Or maybe there's no written contract at all. Maybe it was a handshake and off you go. Again, the default position here, the default setting, so to speak, is that an employer is not allowed to temporarily lay you off without your consent. So again, if you have a contract, I'd like to have a look at it. If there's layoff language there, we'll have to consider it. If there's no layoff language there, if you don't have a contract, then you should be disputing the layoff regardless, Kelly. And if this happened in May, then I do have to say, time is of the essence. All right. Times 98 follows up. Let's deal with a follow-up here, guys, although there's a question from Carrie on YouTube that I'll get to in a sec, or Carl, excuse me. Carl, not Carrie. But Times 98 follows up. Remember, Times 98 was asking whether the employer can inquire about what an employee does while on disability leave. Times 98 follows up and says, I'm currently on short-term disability leave and would like to know what my employer can and cannot ask while I'm on leave. And again, the answer, if you're on a medical leave of absence, Times 98, the answer is very simple. They can't ask much other than a doctor's note confirming that you're on a medical leave of absence. That's all you need to tell them. And really that's that. They don't have the right to ask for any further information. All right, Carl on YouTube asks, Carl is in a situation where the employer will not terminate an employee, but instead he will put pressure on them until they quit. The employer or the owner's own words. Is there any recourse here? Carl then follows up and says, I should add that I'm currently on medical leave due to stress, bullying, and harassment by the owner. He has a long history of doing this to avoid paying severance pay. Carl, I hate to say it, and like many other situations in the employment law world, we do see this relatively often. Employers will make an employee's life difficult and pressure them and inconvenience them to the point that they feel like they have no choice but to resign their employment. Now, Carl, I want to be very clear. If you're dealing with bullying and harassment in the workplace, as you mentioned, and if this is legitimate bullying and harassment where the employer is disparaging you, swearing at you, treating you very poorly, we could think of lots of examples of harassment in the workplace. If this is that kind of situation, Carl, then that is illegal. An employer cannot treat an employee that way. You should be giving us a call right away. Let's have a chat. It is certainly possible that we can right now extract you from that work situation, get you your proper severance entitlements, and get you moving on with your employment. If an employer's behavior, however, doesn't rise to the level of bullying or harassment in the workplace, and maybe they're just not being particularly nice, or maybe they're not being particularly cooperative, that does become a more difficult situation, Carl, where it becomes a bit of a game of chicken, where you have to effectively play defense, so to speak, as an employee and hold out until the employer really has no choice but to terminate your employment. We strategize every single day with employees in these circumstances and figure out where are the leverage points, where can we gain an advantage, right? And where are areas that we have to be careful on in defending against these kinds of situations and making sure that you are in the best position possible to either claim constructive dismissal, again, if you're dealing with a harassment situation, if you're dealing with a situation where the terms of your employment are changing, right? Or alternatively, if it doesn't rise to that level, just protect yourself as much as possible in your work so that you can work productively and with a large degree of peace of mind, because at the end of the day, that's the most important thing. Carl, great question. I would encourage you, again, if you were dealing with bullying and harassment in the workplace, it's an extremely serious matter that shouldn't be taken lightly. Let's have a conversation off air. There are ways that we can resolve that kind of issue with your employer. We'll have to leave it there, folks, because we are out of time. I think I got to all of your questions today. For any of you out there that are watching or listening to this and where a lot of these things are clicking and ringing true when it comes to your employment relationship with your employer, The time is now to act. Do not wait. These kinds of employment problems cannot fester. They get more difficult to resolve the longer they go on for. If you're dealing with a situation with your employer, please reach out to us as soon as possible. Send us an email, give us a call at the office. More than happy to chat through your issue and give you the advice and the guidance that you need. Hopefully, I've done that at least to a certain extent today. Thank you all so much for tuning in. It's been an absolute pleasure. I always enjoy doing these Q&As. We will be having one tomorrow, I believe, at 1 p.m. Eastern time, if I'm not mistaken. And we do these Q&As quite frequently throughout the week. So tune in to the next one. And until then, have yourselves a great rest of the day, a great rest of the week, and we will see each other soon. Take care, everyone.